So the insolvency regime, like we discussed, will come into effect December onwards. Given what the Supreme Court has said in the Essar's case, are you anticipating that creditors will take promoters or promoter entities to the DRT and perhaps even in cases where resolution plans have been implemented?
So the sections which have been brought into play now are for personal guarantors where the companies are in IBC, which means that their applications actually are run through the NCLT, not the DRT, for this kind of process. So if the company has been actually resolved and the resolution plan has been implemented, then the company is out of CRP, out of IBC. I don't think, I'll have to go back and look at it, but I don't think that these provisions apply then, because it's no longer a personal guarantor for a company in IBC.
So if the creditors then has to initiate or invoke the guarantee against the personal guarantor, you do it under the NCLT umbrella and while the insolvency process is on? Under
the normal laws, no. No. So if a company's gone through IBC, the plan has been implemented and everything is done, and then you go after the guarantor, then you're going under your normal enforcement laws and not under the IBC process.
And how would creditors, let's say in Essar Steel, would probably proceed with the going against the RIAs perhaps?
Perhaps, yes, in the DRT or as the case may be. Yeah, correct.
Okay, so once the resolution plan has been approved, the sort of adjudicating authority for personal guarantors and claims against them then becomes DRT, right?
Correct. I mean, it's the normal. There is no change in the law on that count, is what I'm saying. So whether the whether the creditors proceed against Mr. RIA first person guarantees or not is a separate action. It doesn't have a connection with the IBC if they're proceeding after implementation.